The meeting of the Louisiana Tax Commission is hereby called to order. The meeting is being held at the offices of the Louisiana Tax Commission at 1051 North 3rd Street, Suite 225, Baton Rouge, Louisiana. The date is Wednesday, October 9th, 2024. The time is 9 a.m. Please call the roll.
Chairman Rousseau,
Here?
Commissioner Leone,
Here.
Commissioner Romit,
Here.
Commissioner Guidry,
Here.
Commissioner Frazier.
Here.
5 present and a quorum.
Thank you. Being we have no old business, we'll move on to the approval of minutes. Do I hear a motion?
Mr. Chair, I move to approve the minutes from both the September 18th meeting as well as October 2nd meeting.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted. Next item is the consideration of change orders.
Shandrika Banks on behalf of the Louisiana Tax Commission. Today, we have a total of 156 change orders. Staff has reviewed those change orders and requests to approve 153 and place 3 in pending status. Staff requests approval of these change orders.
Mr. Chairman, I move that we approve 153 change orders and place 3 in pending status for reasons given by staff.
We have a motion. Is there any discussion on the motion? Is there any objection to the motion? Hearing none, motion is adopted.
Shandrika Banks on behalf of the Louisiana Tax Commission. Today, we have a total of 9 prior pending change orders. Staff has reviewed those change orders and requests to approve all 9. Staff requests approval of the prior pending change orders.
Mr. Chair, I move to approve all 9 prior pending change orders as reviewed and approved by staff.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted.
Shandrika Banks on behalf of the Louisiana Tax Commission. Today, we have a total of 5 tax sale cancellations, 2 in Ouachita Parish, 2 in Red River Parish, and 1 in Caddo Parish, all due to being erroneously sold. Staff requests approval of 5 tax sale cancellations.
Mr. Chair, I make a motion to approve all 5 tax sale cancellations.
We have a motion. Is there any discussion on the motion? Is there any objection? Hearing none, motion is adopted.
Chairman, next on the docket, we have the motion limine filed by the assessor in the Comstock oil matter. Let me fetch the assessor's attorney. Shandrika, we have the tax reps on Zoom.
Yes. Colton, you ready?
Brian, you ready? Will one of you two gentlemen give Brian a? Sure.
Yes, I am. Pat Crumpton is also joining me.
Brian, any witnesses
No.
for you? Okay. Colton, I'm going to administer an oath to you and Pat, swear you in.
Yep, perfect.
Pat, if you'll turn your. Oh, there it again. Okay, great. Gentlemen, if you'll both raise your right hand, I'll ask you to affirm the oath and state your name. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Colton,
Yes.
thank you. And
Yes.
Pat, okay.
Yes.
And both of you just independently state your names for me, full name.
Colton Singh.
Patrick Crumpton.
Great, thank you. You can put your hand down. Chairman, please have the motion so Mr. Anderson can go first and allow the taxpayer to respond.
Good morning, Commissioners. I know you have a full docket. I'll be real quick on this one. This is another motion to strike for Exhibit 2, which is an email exchange between the tax representative and Comstock's engineer, addressing the issue of whether the pipeline compressor station that was taxed by assessor, the Sabine Parish assessor, is before the sales meter. They're arguing that the compressor station is part of the production train. The problem is this email exchange was not provided to Assessor Tidwell, and that's not disputed. Matter of fact, they didn't give it to Assessor Tidwell until more than a year after they obtained it. Nevertheless, they argue that Assessor Tidwell was made aware of the taxpayer's intent to protest, as it is the taxpayer's belief that this account is prior to the sales meter and therefore should be considered part of the production chain. The problem with this argument is kind of laid out in the email exchange that was provided by the taxpayer. Apparently there was an email exchange on Friday, August the 25th, where Carl Chance, the deputy in Sabine Parish that works oil and gas properties, advised them that he wasn't sure why the compressor station was considered part of the production train. Mr. Crumpton responded on the same day saying that it is the taxpayer's belief that it is before the meter and therefore meets the definition. Apparently there was a conversation by telephone the following week. I don't know exactly what date. And on the following Friday, September the 1st, Comstock filed its appeal, its protest with the Sabine Parish Board of Review. Where it gets really sticky is the email exchange they would like to submit as Exhibit 2, again, between the tax rep and the engineer, is dated September the 14th, 2023, 2 weeks after the appeal deadline. As this document was not produced or presented to the assessor prior to the deadline for filing an appeal with the Board of Review, I would move that it be stricken from the record.
Anything else, Brian? Brian, you done?
Oh, I'm sorry. That's all I have, Commissioners.
Okay, we'll hear from the taxpayer.
Good morning, Commission. My name is Colton Singh. I am here today as a representative of Comstock Oil and Gas. I'm joined by Patrick Crumpton. We believe that the assessor's motion to eliminate should be denied. And I'll kind of take you through the dates as Mr. Eddington did. On August 25th, we did reach out to Assessor Tidwell and Carl Chance, let them know that we did not agree that this should be taxable. We believe that the value for this is captured in other wells values. On September 14th, the email that Mr. Eddington referred to, we received an email from Carl Chance requesting information, an update in information. That was on September 14th, and we used that to reach out to Comstock. We sent that request on, and Exhibit 2 is the response that we got from Comstock Oil and Gas. Mr. Crumpton then called Mr. Chance and relayed that information to him. And so the fact that they're saying that we did not present the information, I believe that that's false. I believe that all the information was presented, and it was before that September 20th board review.
Yeah, so, sorry, this is Patrick Crumpton. So, on August 25th, when me and Carl and Mr. Tidwell was CC'd on the email, I mean, I laid it out there what the production train was and where this compressor station was located. So, I mean, that's as of August 25th. And then Carl responds back on Friday, September 1st, stating that he was at a association of assessing officers and that it was their understanding and belief that the 23 LTC rules of the property be included in protection was not the intent or is included. So they knew what the situation was. And by Mr. Chance's email back to me on September 1st, it did not matter what was provided, that was their belief and that's what they were standing on.
Commissioner, the argument kind of misses the point. Now, if there were discussions on August the 25th where they believe they relayed this information, they can present all of that at the hearing. The specific exhibit that they're trying to submit, I mean, they candidly admit it was not provided to Assessor Tidwell or his office. In fact, it wasn't even created until 2 weeks after their protest to the Board of Review was filed. Again, both this commission's rules and the Louisiana revised statutes on this point are very, very clear. Then again, they can present all the testimony they want about the conversations. What they can't do is submit an exhibit that was not provided to Assessor Tidwell.
Thank you. Questions from the commission? Any question for the taxpayer? Hearing none, do I hear a motion?
Mr. Chair, I make a motion to strike the evidence.
Okay, we have a motion to strike. Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted.
Thank you, Commissioners.
Chairman, I'll prepare an order consistent with your ruling for you to sign next week. Think we move on to the appeals now, Chandrika? Oh, I'm so sorry. I'm getting ahead of myself.
Excited.
I don't know. Good morning, Commissioners. Tanisha Malvo on behalf of the Louisiana Tax Commission. Today, I bring to you the approval of the 2024 tax rolls for the following parishes: Avoyelles, Caldwell, Catahoula, DeSoto, East Feliciana, LaSalle, Jefferson, St. Helena, Vernon, and Washington. Each parish have provided and balanced their electronic roll, their TC 33s, their millage reports. We also received their public service recaps, their financial institutions balance, and provided their quietus affidavit and their approval letter from the Louisiana legislator auditors. Staff requests that those following parishes or previously mentioned parishes be approved.
Mr. Chairman, I move that we accept the tax roll for the 2024 for the following parishes that have been mentioned.
To read them all? Yeah. Okay, all good.
Mm-mm.
As recommended by staff. Okay, we have a motion. Is there any discussion on the motion? Is there any objection? Hearing none, motion is adopted.
Thank you.
Chairman, next on the docket is consideration of decision for the appeal of Highlander Oil. Just since this is the first time y'all have done this, I'll just remind you all what you're doing. This was an appeal you heard several weeks ago. You took under advisement. It has been placed on the agenda today for consideration of a decision. If the commission is prepared to make a ruling in that matter, there's no additional testimony or evidence is presented. The chair can simply entertain a motion from a commission member to set a value, affirm, however y'all want to rule on that matter. If the commission is not prepared to rule, you can simply, again, take the matter under advisement.
Mr. Chair, I move to the decision to be in favor of the assessor of St. Martin Parish against the appeal of Highlander Oil.
So commission members, the motion would be to affirm the assessment as performed by the assessor. And Chairman, you can call
Thank
for
you.
any discussion.
Any discussion on the motion? Okay, before we do objection, let's do a roll call on this one, please.
Commissioner Leone,
Yes.
Commissioner Romick,
Yes.
Commissioner Guidry,
Yes.
Commissioner Frazier,
Yes.
Chairman Roussel.
I abstain. I was not present for the hearing, so I'm going to abstain from voting.
4 yeses, the motion passes. Chairman, I'll prepare a decision consistent with your ruling. Chandrika, now can we move on to appeals? Wonderful. All right, if you'll be testifying in any of the appeals on today's docket, you're not an attorney, so you'll be offering testimony. I'll have you stand up. I'm going to administer an oath to you, and I'll have you affirm the oath individually when I indicate to you, and I'll have you state your name. So you'll be testifying. Go ahead and stand up. Praisers, I'll handle you all separately. Please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. 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 Y'all may all have a seat. Appraisers, if you will unmute and turn your cameras on, I will administer an oath. I will indicate to you individually to affirm the oath, and then you can remute and turn your cameras back off. Please raise your right hand. Do you swear or affirm the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Nicole?
Nicole Singley, I do.
Thank you. Paul?
Paul Burnett, I do.
Mark?
Mark Gillespie, I do.
Thank you. Sandy?
Sandy Kennedy, I do.
Luke?
Luke Brewer, I do.
Thank you. George?
George Wallace, I do.
Thank you. Mike?
Mike Cater, I do.
Thank you. And Cody?
Cody Lowry, I do.
Thank you. Is that all of them? Okay.
The first appeal we'll take up today is the appeal of Bruce Schuman versus Assessor L.G. Williams in the Orleans Parish Board of Review, docket number 23-221-71153.
Good morning, Commissioners, Mr. Alvarez, Joseph Dronette, with Chaff McCall, here on behalf of the taxpayer, Bruce Schuman. We're here today on an appeal of the Board of Review's decision to affirm the Orleans Parish Assessor's Office's appraisal of the improvement at 404 Notre Dame Street, Apartment 2 in New Orleans. Before the hearing, Mr. Alvarez and I, on behalf of the taxpayer, we stipulated to the value of the land at $89,500, which I believe comes down to $62.80 or 90 cents per square foot. It's on his Exhibit 1. So we have the stipulation for the land, so we're just here on the improvement today. And so the taxpayer would like to advance 3 points today, mainly that first, the original appraisal by the Orleans Parish Assessor's Office was inequitable and doesn't comport with the statutory requirements for determining the fair market value of an improvement. Number two, show that the supplemental appraisal that the Orleans Parish Assessor's Office made is irrelevant because it doesn't go to support the Board of Review's determination as to the value of the improvement, and also that it is grossly higher than not only the Orleans Parish Assessor's Office original assessment, but it's close to $130,000 over the LTC's assessment. And so it's inequitable that such a high number would be presented, and it really seems it was presented as though to discourage a taxpayer from pursuing an appeal. And then lastly, although the LTC's appraisal was much more reasonable than the appraiser's office, Orleans Parish Appraiser's Office, we think that it could have done a better job at accounting for just the value of the improvement, opposed to conflating the value of the improvement and the land together. And with a few modifications to the formula, we believe we can come to a value that's much closer to that the taxpayer originally prayed for. And so with that said, I want to elicit some testimony from a few individuals, namely Ms. Cassidy, Mr. Alvarez, and Mr. Bennett. Do you want me to go forward with that now, or do you want Mr. Alvarez to go forward, commission ask questions, then I ask questions?
You can go first. Yeah.
Okay, Mr. Alvarez, I'd just like to start with you, sir. Just a few questions. How did the assessor's office originally appraise Mr. Alvarez's property?
You mean Mr. Schuman's property?
Yeah, you're right. Sorry.
Okay. Because, yeah. All right, so the valuation was.
I assume it'd be the same way though if you live in New Orleans, right?
It
Okay,
would be, yes.
anyway, yeah.
Well, that's actually a good point. So condos are valued as a microcosm. So they're valued as their own neighborhood. It was done by a mass appraisal, CAM-assisted mass appraisal valuation. That is why there's a differential between that value and the revised appraisal, because the revised appraisal is a fee simple appraisal as opposed to a computer assisted mass appraisal.
Okay. And so do you understand that the way this computer mass appraisal system appraised several properties in the building, it appraised 9 different units at the same value per square foot? Would you say that assessing 9 apartments without a 9 apartment building rooms essentially at the same value is equitable? Sorry about that.
Yes, I would say that the valuation that was performed was an additive model. It was a median price per square foot applied to the square footage of all the properties. So therefore, it is the definition of equity. Everybody was valued the exact same way.
Even if the condition of the property is different? Would you say that assigning the same value for different conditions is equitable?
I would say that if we assign different conditions, we don't take that in consideration when we value the property. That's why we have a month-long open roll period where taxpayers can come and present documentation to support any kind of condition adjustments. That was not the case. Your client did not provide any documentation for condition either through the open roll period, the board review period, or the Louisiana Tax Commission exhibit period.
And so you're saying that the way your system works, it does comport with the statutory requirements to determining fair market value, right?
Yes,
Okay. So you're saying the system does utilize all available data that is specific to the valuation of property used to determine the fair market value of property?
yes.
So an interior inspection was performed here?
No, by law, we're not allowed to do interior inspections. We're allowed to use any information that we can collect to make a reasonable evaluation of property. We're not required to do an interior inspection. We're not allowed to go inside unless we get permission by the taxpayer. Once again, taxpayers are allowed during the month-long process to request an inspection of their property to make any kind of interior condition and reductions. That was not done by your client. Your client did not give us the permission to go inside of his unit, nor did he provide any documentation as to condition.
In the supplemental appraisal, the appraiser notes that there were some cracks in the concrete flooring and water stains on the ceiling. How'd that information get to the appraiser's office if Mr. Schuman didn't provide any information?
You want
From Modria, the system for the taxpayers to file for the Board of Review. He submitted 2 photos. One cracks in the concrete floor and a small water stain on the ceiling. Oh, sorry.
Pass this to the commissioners, please. And
So the
please
Modria
submit
system is
it
for
just
the
that-
taxpayers to file with the Board of Review.
It's not an exhibit. It's just a demonstrative to help elicit testimony. I'm not submitting it for the record.
Present us anything that was not presented in your appeal prior to.
Okay. And so what you were saying, Mr. Alvarez, isn't true then? We did submit photos to this process?
In Modria, there were photos for the Board of Review,
And,
not to the Orleans Parish Assessor's Office, but we are able to see those photos.
and so that, the appeal from the Board of Review's decisions while we're here, and those photos were used in that process.
Correct.
Well, we can only speculate as to what the Board of Review did or did not do, as we are not the Board of Review.
Correct.
So just to put a bow on it, you do think that the original appraisal complied with the statutory requirements, even though same value is applied to different conditions of property?
Yes, absolutely.
I just have a few questions for Ms. Bennett now. Excuse me, Ms. Cassidy, I apologize. And looking at the supplemental appraisal that was performed, do you know why you were asked to make a supplemental appraisal, since the purpose of this hearing is to, affirm or deny the decision of the Board of Review?
Can you repeat that?
Yeah, so do you know why you were asked to make a supplemental appraisal whenever the purpose of this function is to review the providency of the original appraisal that was affirmed by the Board of Review?
That's the process of our appeal. We
Okay.
submit information.
You submit information that's different than your original assessment?
Well, we individualize from mass. We're not asking for this number.
Okay, you're
We're
not,
just presenting, not the 611.
okay, okay. So I guess that would be why the original assessment valuation wasn't incorporated into your reports, because you did a fee simple report, is that right?
Yeah, it's a fee simple.
Okay. Can you explain why that supplemental report came in at such a higher value than the LTC's appraisal?
Well, adjustments are done differently. I also used a comp on Julia Street, which is very comparable.
And looking at the deduction for the condition of the unit, I think the deductions you made were about $100,000 less than the deductions made by LTC for condition. Can you explain why there's such a variation there?
Yes.
Specifically for units 8 and 15 at the same building of the subject property.
So adjustments, in our office, we have a standard procedure for consistency.
And why is that more accurate than the values that the LTC used? Maybe if yours is standard and theirs is individualized,
Well-
which is more accurate?
Appraising is subjective. You know, we have our procedures, the LTC has their procedures.
And are you in any position to say which is more accurate?
No,
Have you ever been inside any of the units at 404?
I have not.
Do you know why the two that you utilized were assessed at an excellent condition and Mr. Schumann's was at an average condition?
Well, I'm giving him the benefit that it's average because I do not know. The two comps within the building, the multi-list had them listed in excellent condition.
So what would happen if the majority of the units were in the same condition as those that were deemed to be excellent? Wouldn't that really just be the average of the building?
No, we have open roll for a month and the city has the Board of Review. Any information on condition at that time, the taxpayer should bring, photos or ask for an interior inspection.
I don't think that answered the question. So if almost every unit is in excellent condition, wouldn't the average for the building be excellent? Wouldn't that be the new average?
Yeah, that's not how appraising works.
Okay. And so you did note in your appraisal that there were cracks, as we mentioned in the floors earlier, right?
Correct.
And you noted that there's water staining in the ceiling, certain
A small
spots.
corner.
Okay. Why would that be average and not below average?
Well, the water stain is very small and the cracks in the concrete floor, this is a turn of the century manufacturing building. Aesthetically industrial in character, such as exposed beams, exposed brick, exposed ductwork, concrete floors, old wood floors. So it's part of the building.
Okay.
It's not damage.
Do you know if in 1996, when these were converted to livable spaces, if the concrete wasn't cracked?
I do not necessarily.
So you can't say if it's damaged or not.
No.
In your assessment, do you think that you utilized all,
Excuse me? What was that? Can you repeat that?
sure. Do you think in your assessment that you used all available data that's specific to the valuation of the property to determine the value of Mr. Schumann's improvement?
Yes. We didn't receive any data, estimates or anything for damage.
What's an extra assumption? Excuse me, an extraordinary assumption? As used in your report?
Yeah.
An extraordinary assumption.
I'm asking Ms. Cassidy.
Okay.
He's the author of the report.
I'm just giving you the definition.
Right. It's something that's believed to be true, but you can't substantiate it.
And so if it's actually proved to not be true, then the validity of the report's called into question.
Buildings of this character typically do have cracked concrete floors.
Okay. I don't have any more questions for you, Ms. Cassidy. Thank you for your time. And lastly, I just have a few questions for Mr. Bennett, LTC appraiser. Okay, no problem.
Good morning, Commissioners. Russell Ambrose for the Orleans Parish Assessor's Office. So this property is a condominium property in the warehouse district. This property was valued originally at $550,200, which was affirmed by the Board of Review. The tax commission staff appraisal is $484,000, which is a slight difference from the original valuation that we did. A valuation of 12.3%. We performed a fee simple appraisal. As stated earlier, a mass appraisal or initial valuation was done by mass appraisal. The fee simple appraisal is a more specific appraisal to the specific property as opposed to a valuation of a large swath of properties. As stated before, condominiums are a microcosm. We treat them as their own individual entity. So we try to take sales within the building, if at all possible, to value properties in the building. So the original valuation was done by using a median price per square foot, applying that to the square footage of the properties. That's $387 a square foot for the total fair market value. Penthouses were valued at $580 per square foot. That's because penthouses typically sell for a premium than regular units. The particulars of this property is that this is a really desirable condominium development. There's a high retention rate. There have only been 11 sales in the building from 2018 to present. 8 regular units, 3 penthouse units. There's rooftop terraces and there's parking garages in this development. That's amenities that are included in the sale. The subject is a 1,421 square foot condominium, which equates to a 2.83% common elements. Just to give you a little basis, there were 1,148 appeals that we had to the tax commission, with 75 of them being condominiums. So only 6.5% of the condominiums throughout the entire parish appealed to the Louisiana Tax Commission from the Board of Review. This is the only unit in the building to make an appeal to the Louisiana Tax Commission. Subsequently, there were 6,200 appeals to the Board of Review, with 477 condominiums being appealed. That's 7.7% of total appeals being condominium units. Only this unit and Unit 19 made an appeal to the Board of Review. And at the board, after the Board of Review, only this unit made an appeal to the Louisiana Tax Commission. We think that our valuation is a fair valuation. We asked for the tax commission to uphold the Board of Review's valuation. We do recognize that the revised appraisal is significantly higher than the valuation that was done by the Board of Review in CAMA. But to err on the side of caution, we're not requesting the revised valuation. That is just kind of to support the valuation that was done originally. We would ask that the tax commission uphold the Board of Review. The tax commission's appraisal is not out of the ballpark of our valuation. Like I said, it's a 12% reduction. We just think that there's a couple of different valuation methods that could have been done a little bit differently, a couple of little adjustments that could have made a little differently. The only thing that really stood out to me was that there was a penthouse unit, comp number 3, that was used as comparable, and it was a 60% difference or adjustment made to the penthouse comparable. In my opinion, that doesn't seem to be a very comparable sale. So I think if you would make adjustments a little bit differently, it would come close to the value of the 550. But like I said, it's not out of the ballpark. And to have full transparency, we did offer to settle the tax commission's appraised value with the taxpayer to expedite this appeal.
Thank you. We'll hear from Mr. Bennett, the LTC appraiser.
Paul Bennett with the Louisiana Tax Commission. I personally appraised the property at 404 Notre Dame, Unit 2, with a undisputed land value of $89,500, an improvement value of $394,500 for a total value of $484,000.
Thank you, Mr. Bennett. You had questions for Mr. Bennett?
I do. I'd like to just address a couple things that Mr. Alvarez said first while they're fresh on my mind, and then ask Mr. Bennett a few questions. Mr. Alvarez said that this taxpayer is the only taxpayer to make an appeal to the LTC, and that's true. I pulled at least 9 properties from the same building off the assessor's office. 8 of those 9 went up 3.9% in their assessment from 23 to 24. Mr. Schumann's went up by 43%. That's a grossly excessive percentage in comparison to the 3.9% assessed to all the other units. His went up by $165,000. The second closest to that was $25,900. That's a stark contrast in the type of assessment his unit received compared to the others. So that might be why he was the only taxpayer that made an appeal. And with that being said, I would like to ask Mr. Bennett just a few questions. Good morning, Mr. Bennett. Thank you for being here. Let me pull up your assessment very quickly. A quick question. Is it inappropriate to deduct the land value off the top of the sales price? I think you account for it later, but is there anything appropriate with making the land value reduction up front?
Could you clarify your question?
Yeah, so we have a sale price for comparable to of 690,000.
Mhm.
So if we determine what the land value is, as the assessor's office does, multiplies $1 per square foot by the square feet of land, you get the land value. Is it inappropriate to reduce the sale price by the land value up front?
No, because what the actual property is the land plus the improvements. It's the improvements onto the land. So in a fee sample appraisal, those they're integral together. They're tied together. So you're basically appraising the land and the improvements to that land. So the separate cost, unless you are just simply looking at if they were to have disputed the land value, we'd develop a separate land value. But within the sales comparison approach, that's not applicable to deduct it out because that's essentially what you're valuing.
And so here we're contesting just the improvements value. That's why I was asking if we could deduct the value of the land. That way we're only getting to what portion of the sales price is attributable to the property, to the improvement itself.
Mr. Bennett answered the question. Paul, stop for a second. Mr. Bennett answered the question. He said they're tied, integral to each other. So let's move on.
Okay. Well, with that being said, if I ran a calculation using your numbers, but I deducted the value of the land from $690,000, would you have an issue with that? And if I used your same condition deduction and your same square foot deduction and came to a number, would you have any issue saying that, yeah, that's the value of the improvement for this sale?
Well, technically that methodology isn't really appropriate because you're taking the land value as stated by the assessor's office, and basically, again, my appraisal is looking at a whole. It's looking at the land plus the improvements. So you can't just the deduction of that number. It would give you there's not really a method for just deducting land to say the improvements is worth essentially this amount. It's like I said, it's integral, it's tied together. So it's one, there's one unit. So that's not really a method that would yield accurate results.
Okay. I guess the reason why I thought to do it that way is because the assessor's office uses this sales method and then on the back end does delineate the square footage for the improvement and the square footage for the property itself. They use these comparables to get to a value for the improvement. So that's what I was trying to do with your sale here that you use as a comparable.
Yeah, and that is a mass appraisal methodology, not necessarily a fee simple appraisal.
Okay. Then I'll just make my case with the methodology I use, and I understand the difference. So I'll just get that done real quick and then I'll be finished. So this $690,000 figure, I subtracted the value of the land that I determined based on, the square foot per land that was assessed by the assessor's office, which was $62.98 per square foot. I multiplied that times, the square foot of the building, or excuse me, of the property, which was 1918. I got to a total of $120,795.64. I deducted that from the sales price, which got to $569,000, $569,204.36. I then used your condition deduction and your, I then used your condition deduction and your square foot difference reduction and got to a total of $341,000, $341,704.36. Would you say that that amount grossly undervalues or underestimates the value of the improvement? $341,704.36?
Yes, absolutely it does. That methodology is incorrect, and using one of the basic core appraisal concepts, the sales comparison approach, the market shows very accurately the value of this property.
You're right. It does. It includes the value of the land and the improvement. That's the
Again,
confusion
yeah,
that I have.
which are tied together.
Yes, sir. I thank you for your time. I have a witness fee check for you that I will mail out
No,
for Mr.
stop.
Alvarez.
He works for the LTC. He doesn't get a witness check. He's testifying here on behalf of the LTC.
I subpoenaed him pursuant to the Administrative Act.
It doesn't matter. He's
Okay.
here in his LTC official capacity, so that's not necessary.
Okay, well, I'll just disregard that.
Sorry,
check.
Paul.
I was just trying to do what's proper. The act says for everybody subpoenaed to get a witness fee. That's all I have. Thank you, commissioners. Thank you, Mr. Alvarez.
The original subpoena asked Mr. Bennett to drive from Bossier, and so the expectation is the taxpayer would bear the burden of the cost of the mileage. Because the taxpayer requested these appear to be Zoom, certainly no need to pay a witness fee.
Thank
Okay.
you. Okay, questions from the commission?
Mr. Chair, I have a question. I have a question for the taxpayer. I'm confused of what you're actually asking for. You've done elaborate calculations that support a higher number than what it appears the appraisal of what you're asking.
So we'd be asking for the improvement to be valued at $341,704.36. And that would be $240.47 a square foot. I believe the taxpayer originally prayed for around $210 a square foot. And so by trying to use the LTC's appraisal, with some modifications, we arrive at $240.47. And I think that's a good faith improvement, to get something to get to something more reasonable.
I have two more questions for you. What are you saying the condition of this unit is? Is
I
it,
would
is
say-
a crack? Is it something that someone can fall into and twist an ankle, or is it a seam that's notable in a concrete floor?
It looks to be a big seam, not something that anybody could fall into.
So there's really not damage, so to speak. There's a seam in the concrete.
Well, the point is, originally, it may have been one slab of concrete without this crack, and so damage to the concrete itself by virtue of the crack. That was the point.
Mr. Chair, I'd like to make a motion to, noting that the assessor and the LTC both rated this property as average. There are two common comps in the building. The conditions are excellent from both parties on both of those. As has been done in the past, noting that the assessor's adjustments for condition is their methodology. LTC has a different methodology. I've looked at the averages of those comps, and I would like to propose an assessed value in total of $536,200, which is the average of all of those comps, with land at 89.5, improvements at 446,700.
There we have a motion. Is there discussion on the motion? Is there any objection to the motion? Hearing none, motion is adopted.
Thank you, commissioners. Thank you, Mr. Alvarez.
No worries.
Here, and do I pay you? I was just trying to do what was right based on the notice I received.
Yes. Okay.
All right. Yeah, the letter said pay, and I didn't want to not pay somebody. You give this to Cassie. Cassie, here's the witness fee check. Mileage and $50. That's what the.
Y'all do that business outside, please. We're gonna move on with the meeting.
I've taken up enough of y'all's time. I apologize.
The next appeal we'll take up today is the appeal of Christopher Lademacher versus Assessor L.G. Williams in the Orleans Parish Board of Review, docket number 23221-77046.
Taxpayer can go ahead.
Hi, good morning. My name is Richard Morales. I'm appearing on behalf of the taxpayer, Mr. Christian Lademacher. May it please the commission, I submitted a memorandum. We were retained after the appeal was initially filed by the client. So this came after the initial filing of the appeal. I just wanted to.
Hold on one second.
Sorry.
You get sworn in right before.
Oh,
No.
yes. Okay, he's gonna try and swear me.
Oh, good.
Thanks, sorry. So, sorry, jump back in. I submitted the memo. I just want to make sure that you received it. I don't know if you had a chance to review it, but for purposes of making the record, I would like to just quickly run through it and then reserve any time at the end to answer any questions you may have. And so just to start, we're not here to contest the land value, and really we're not here to contest the appraisals. The argument, as you may have seen in the brief, is that it's a constitutional one, one of equity. And it's one that we've presented to this commission before, albeit a prior iteration. And we believe we are grounded in the, supported by the U.S. Constitution, the state constitution, state statute, and the Louisiana Tax Commission's own rules and procedures, and policies against the practice of chasing sales. And with respect to this property, we believe that the magnitude of disparity that is evident based on the neighboring properties is the result of this property having a recent recorded sales price, while the others either have no recent sales or were recorded at a sales price that was not the actual sales price. So just to briefly step into history, there was a original notice of assessment issued on July 7th for 1.175, which is exactly what the property sold for in March of 23. And that is included as Taxpayer Exhibit 1. Taxpayer Exhibit 2 is the revised notice that the client received, which had the value of $1,081,000. Notably, that value is exactly 92% of the sales price. And the reason I highlight that is because I think it shows a pattern, and not to go into the whole city, but if we just look at the comps that are included in the LTC's appraisal and in the assessor's appraisal, there are 4 properties total between the two, 3 of which had sales in 23, all 3 of which were reassessed or assessed for the 24 tax year at exactly 92%. The 4th was a 2022 sale that was reassessed at 120%. And so it is with this in mind that we believe that there's clearly an indication of sales chasing here. And I also want to point out that we recognize that there is, based on the system that is used, there is a chance that this could happen where the system does factor in and come to a number that is close to sales price. We're not pretending that it may or may not happen. But again, with just the comps and the subject property, it seems unlikely that all of them would be reassessed at exactly 92%. And so that's kind of how we end up here today. The client felt like looking at and not just on the block that we've included in the brief, but in the district as a whole, there are properties that were sold but not with recorded sales prices that did not experience a jump or were reduced, including some of the ones we pointed out in our brief. And again, the reason the taxpayer chose to come to this phase is that ultimately we know that sales chasing results in a shift of the tax burden to taxpayers who more recently acquired their property. If my number is right, even if it's right, and if my neighbor's is half right, the burden is still improperly shifted to me. And so that brings us to the relief that we're asking for. And so you'll see in the tables we've included, we just took the properties, neighboring properties on the block, which are of substantial condition and geographic relationship. So for the record, we've included as taxpayer exhibit 3, the comparables from the assessor, just the printouts, and then exhibit 4 is the map showing the block. But on just carving out the land, which we are not challenging, which appears to be uniformly assessed. And if you look at on a price per square foot basis, we have a range from 311, 192, 158, 196, 173, and 114. In addition to the taxpayers who was reassessed at $327 a square foot. And so immediately it jumps out that there are 2 that are the clients double 2 of the properties on his own block. And so I guess the relief we're asking for here again is just a uniform treatment with just the neighboring properties. We're open to looking at if there are other comparables in the district that you would like to use for this practice, but this practice, we did not come up with this on our own. This is based on prior appeals and experience with the assessor's office having to come to this level. This is what prior commissions have used, so we chose to do the similar. And also pointing out that this is the only taxpayer's form of relief to request that they are uniformly assessed, because we can't ask for everyone else to be increased in proportion to their fair market value. We can only make a plea for our own value to be reduced in line with our neighbors. And so I just want to point that out because I know that in the past, the assessor's office has argued that this method is not an appraisal method, and I understand that. But we point out in light of what we feel is convincing evidence of the use of sales chasing, we think that this is an appropriate remedy. And so just kind of to get back to the numbers here, when we took the average of the properties on the subject square block, we came to a square foot of 195.56. We multiply that by the square footage of 2,980 and come to a improvement value of 582,761. And this is our best guess at what the average square price should be based on a uniform assessment of all similarly situated taxpayers. And so again, just to summarize their argument, we feel very that our argument is supported in both federal and state law, as well as the commission's own rules and regulations, and request that the commission reduce the property to treat to ensure uniformity across the taxpayers.
Okay, thank you. Mr. Alvarez?
Yes. So the property was originally valued at $1,081,000 based on the reappraisal that's required by the Constitution every 4 years. It was reduced at the board review to $1,057,500. There's an appraisal by the tax commission at $990. We did a fee simple appraisal, so we wanted to get something more specific to the property than the mass appraisal. Surprisingly, it came out a little lower, $983,000. We offered to settle with the taxpayer for that amount. They declined. Just to go into it a little bit, the owner's docs, yes, there was a sale in May of 2023 for $1,175,000. The issue with this is that this is a new construction property. It was closed in February of 2020. It's a newer constructed property. Just to clarify, that he keeps saying sales chasing, sales chasing, sales chasing. Nothing here is a demonstration of sales chasing. Sales chasing is if we have a neighborhood and you have a sale, no one else sells, and we only value your property. That's sales chasing, because we've only valued that one property via a sale. We didn't value anyone else in the neighborhood. If we value everyone in the neighborhood, and we're using a mass appraisal, that's not sales chasing. If it comes out close to the sales price, that's not sales chasing. In fact, the only way to value property in the sales comparison approach is using sales of property to value property. So sales chasing is I value one property in a neighborhood, nothing else. That's what Club New Orleans versus the Board of Review was all about when the tax commission said you can't sales chase because they valued one property and nothing else. The information provided by the taxpayer is not an indication of any kind of ununiformity or inequitable valuation of the property. None of the properties are comparable to the subject property. In his information that he provided, 7461 Benjamin was constructed in 2012. It's very good condition versus his excellent condition. The sale was for $500,000. It's not in MLS. It wasn't even used in the valuation of property. It wasn't even put in the universe of sales because it's not an arm's length transaction. 342 Milladon has an age freeze on it. It's an original building to the neighborhood when it was constructed. It's not new construction. It's also in good condition, which is a lower condition than the excellent condition of the property. The sale that he's stating on 2016 is a subdivision. It's not even a sale. It's when they split land into two different properties. 338 Milladon is not an arm's length transaction. It's an original property as well to the neighborhood in Black Pearl. It is an average condition, which is substantially different from the excellent condition. Same thing for 7458 Benjamin. It's an original building. It's an average condition. The sale he mentions is not a sale. It's a tax sale. It's a redemption of a tax sale. So that's not an arm's length transaction. You can't say that we didn't value it based on the sale because it's not actual sale. Same thing with 7462 Benjamin. It was a succession in 2000. It's 24 years old and it was a succession. Of course, we're not going to use that to value the property. And it's also an original building. So it's not anything that we're doing that's valuing property in an inequitable manner. It is equitable. If you look at 7463 Benjamin, it is the closest to the condition, size, and closest to the condition, the size of the property. It's also in excellent condition. It's 2,904 square feet as opposed to the subject 2,970 square feet. They're relatively the same size. It was valued at $1,029,000. The taxpayer's value is slightly higher. It was valued at $1,081,000. That is a difference of $60,000.
You said 7462. Did you mean 301 Cherokee? Just to clarify.
So our parcel identifier is 7463 Benjamin. The municipal address is 301 Cherokee. It's right there, what with the property. It's 2,904 square feet for Cherokee. It's 2,970 for Benjamin. It's $1,029,000 for Cherokee. It's $1,081,000. It's a little bit higher because it's a bigger building and it has a different size. But it's $60,000. Those are the two that are closest in that neighborhood, and those are the ones that are valued. You can't say that it's unequitable. That just kind of shoots a hole in the theory. The ones that are not valued the same is because it is an age freeze and it's an original building to when the neighborhood is constructed. Of course, we can't value that the same. That is not equitable. We can't value an original building to a new construction. We use a cost approach for new construction because there's no depreciation. And we use a sales comparison approach for an original building. And that's demonstrated in Lakeview and numerous other areas, Gentilly Terrace, where you have a discrepancy between properties that were built post-Katrina and pre-Katrina, if that makes sense. And that's it.
Okay,
Sorry.
we'll hear from the LTC appraiser, Mr. Gillespie.
Yes, sir. Mark Gillespie with the Tax Commission. I appraised the subject property using 3 comparable sales within reasonable distance of the subject. Determined the market value to be $990,000. The undisputed land value, was $104,000. Improvement value $886,000.
Thank you, Mark.
Yes, sir.
Questions from the committee?
I'm sorry, if I may just respond to a couple of the points. I wanted to point out our numbers, we actually used intentionally the actual assessed, the fair market value assigned, not the assessed value, to disregard the age freezes because the assessor's office does revalue those properties every year. So in our tables, you'll see that that number that is included is not, we're not getting a square footage number based on the frozen value. We're getting it on the number that was reassessed in this past year. And then also to, just to point out that to say that these are not comparable to the properties on the block by saying it's new construction, none of the comparables in either appraisal report were, including the assessors, were new construction as well. So if it's okay to use the old ones, we're just asking that, again, we use older properties that are on the same block in this case for the taxpayer. Thank
Okay.
you.
Questions from the commission? Hearing none, do I hear a motion?
Mr. Chair, I have a motion to accept the assessor's value of $983,000, which is $104,000 of land, $879,000 of improvements, total of $983,000.
Okay. We have a motion. Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted.
Thank you.
Next, we'll take up the appeal of Eli Edwards Enterprises versus Assessor L.G. Williams and the Orleans Parish Board of Review, docket number 23221711104.
Taxpayer?
So the first property we'll take up is the 4230 South Carrollton Avenue. And that's briefing sheet 3, please.
Yes. Okay, property 4238 South Carrollton Avenue. We provided the insurance as proof of, the value that we were going to provide. Yeah, he had provided the insurance to go by, to accept the value, to request to accept the value on, because the value that they had provided was higher, so he had discussed with, I forgot, I don't have the paperwork with me because it was just put on my desk yesterday evening. I do apologize to come to the hearing today at 290,000. So we had, trying to decide with the last person that he spoke with and asked the hearing officer to, we agreed to decide on 290,000 to ask the hearing officer, the court, to decide if we can agree on 290,000.
Okay. And ma'am, just to clarify, it's not a court. It's just a tax commission. The court will be
Okay.
the next step. So,
All right.
Mr. Alvarez, City of New Orleans?
Yes, this is a multifamily property located in South Carrollton Cemeteries neighborhood. We initially valued the property at $337,300. It was affirmed by the Board of Review. The tax mission came out higher at $360,000. And while we think that's supportive of our value, we're asking the commission to affirm the Board of Review, which is the lower value of the two.
We're from the LTC appraiser, Mr. Lowry.
Yes, sir. This is William Lowry with the Louisiana Tax Commission. I personally appraised the property, and I came to using the fair market value, I came to a market value of $360,000 with an undisputed land value of $139,800 and an improvements value of $220,200.
Thank you. Questions from the commission? Hearing none, do I hear a motion?
Mr. Chairman, I move that we accept the parish appraisal at $139,800 for the land and improvements at $197,500 for a total of $337,300.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted.
Next, we have the appeal of Eli Edwards versus Assessor L.G. Williams and the Orleans Parish Board of Review, docket number 23-221-71107, and it's for 2520 Palamro Street, briefing sheet 4.
Can you repeat the address one more time? Palmyra. Right. Okay, that's okay. Okay, ready? Okay, again, we provided the insurance, documents for that property. I don't have the insurance paperwork with me, but whatever you guys have. Yes.
Mr. Alvarez?
So this property is, pull this up real quick, my apologies. Is another multifamily property. It's in the two-lane Falstaff neighborhood. We originally valued the property at $228,300. The Board of Review affirmed that decision. We did a revised appraisal. That revised appraisal came in at conflicting numbers. I have one at 213 and one at 212, and roughly the same. It's slightly lower than the valuation that we initially did. We think that that is a good market value for the property. The insurance is $150,000 plus the land would put it well over $200,000. We don't feel that the tax commission's appraisal is an accurate indicator of value. The three comps that were used on 3022 Palmyra is in severe disrepair. It says that the sale will not go conventional, must be a renovation loan or cash. Property is part of succession and may be sold as part of a package. Utilities were not on. 2400 Dumaine was a bond for deed, Section 8 housing. It's not an actual sale. A bond for deed is not an actual sale. And 2534 Dumaine was also a succession sale. The notes in there say that this property actually appraised for higher than the sale price, which means instant equity, which is in the notes of the MLS. So barring those, in lieu of those three sales, we feel that the $212,000 is an accurate indicator of value. And that's what we're asking for. I can give you the breakdown because I sent the wrong breakdown in.
Can we hear from the LTC appraiser, Mr. Wallace?
Yeah, George Wallace, Louisiana Tax Commission. I did appraise the property, had a sales comparison approach of 185,000, a gross rent multiplier analysis of 183,000, for a total value of 184,000. That's 55,800 for the land, 128,200 for the improvements. I felt like the comparables were part of two of them part of a succession, but they did fall in line with the value. The only comment on the appraisal by the assessor is that their adjusted range is 175,600 to 186,525, and their final value is 212,000, which is outside of that range.
Questions from the commission? Hearing none, do I hear a motion?
Mr. Chair, I move to take the average of the assessor's appraisal, LTC's appraisal, come up with a total value of 200,000. That's 55,800 for land. In 1 second, I'm doing the math. So 55,800 for land, 144,200 for improvement.
Okay, we have a motion. Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted.
Next, we have the appeal of Eli Edwards Enterprises versus Assessor L.G. Williams and the Orleans Parish Board of Review, docket number 23-221-72107, and this is for 947 North Carrollton Avenue.
Okay.
Oh, 200,000.
Sorry, the next one is 23-221-73144, and that's for 2414 Feliciana Street.
Go ahead, ma'am.
we provided insurance documents for this property also. And can you provide the, insurance amount for me, please? Yes. We had provided 89,300.
Okay, that's what you're asking, ma'am?
Yes.
Okay. Mr. Russell, we'll go with,
Oh, yeah, sorry. So this property is, another multifamily property on, Feliciana Street. We originally valued the property at 118,000. It was affirmed by the Board of Review. All of our values are what and what. The tax commission's appraisal is 115,000. Our revised appraisal is 116. The Board of Review's at 118. You're talking about a $3,000 difference between all appraisals. I mean, everything's in the book, in the range.
thank you, Mr. Russell. We'll now hear from the LTC appraiser.
Yes, good morning. Luke Brewer with the Louisiana Tax Commission. I appraised the property at 2414 Feliciana Street. At the inspection, it was noted that the addition was boarded up and was not accessible. And according to the property manager, it was not habitable. Given that, plus the evidence of mold in multiple rooms in one of the units, I deemed the condition to be poor to fair. All three comparable sales and the comparable sales approach are within 0.3 miles. After appropriate adjustments, the value range between 94,500 to 131,700, leading to an opinion of value of 115,000. An income approach was made, however, no weight was given to it. Two of the three sales are within 0.4 miles away, and all three are in better condition than the subject. And the subject's only being one unit and rent controlled. And for those reasons, even though the income approach indicates a value of 180,000, no weight was given to that approach. And my final indication of value was 115,000, 8,200 being the value of the land, and 106,800 being the value of the improvements.
Thank you, Luke. Questions from the commission?
Mr. Chair, just a quick question for the parish assessor's office. I believe you're praying for the 116 in total, or is it the 118?
Oh, no, our revised appraisal is 116, but, we have no issue with, like I said, in lieu of the condition of the property, settling the tax commission's appraisal value of the 115, because like I said, they're all within the same ballpark, and there's some severe, condition issues to this property.
Mr. Chair, I move to accept the total of 115,000, 8,200 for land, 106,800 for improvement.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted.
Next, we have the appeal of Eli Edwards Enterprises versus Assessor L.G. Williams and the Orleans Parish Board of Review, docket number 23-221-74041, and it's for 2829 South Johnson Street.
We're asking 60,000.
Thank you. Mr. Alvarez?
Yes, sir. All right. So this property here is another multifamily property. It's located in the Central City North neighborhood. We originally valued the property at 98,700. The Board of Review affirmed it. We did a fee simple appraisal, came in right close to the value, slightly under at 97,000. We think that that is a good indicator of value for the property. The only issue, so if you take the insurance, $80,000 of the insurance plus the land is putting it above 90,000 as well. The only issue we have with the tax commission's appraisal value is we don't agree with the quality reduction. These properties seem to be all of the same quality. If you were to remove the quality reduction for the property and add the value back to the sales, you'd come in right at the value that the property should be worth. It would come in around right under the 90,000.
Thank you. We'll hear from the LTC appraiser, Patrick.
Patrick Matthew, Louisiana Tax Commission appraiser, personally inspected the property at 2829 South Johnson Street. It's a double considered to be in fair condition. Three comparable sales are shown. Adjusted sales range from 61,200 to 77,870. In regards to the quality adjustment, in my opinion, after looking at the property and all evidence, as well as the MLS pictures for the comps, I deemed the subject to be in low quality as a comparison. You can see in the pictures shown that two of the comps have higher pitched roofs, full porches, and also in the MLS sheets, all three of the comps were at least renovated no later than 2017, and were all deemed to be in better quality. So that's the reason for that. And a income approach was also done as well. It deemed a value of 79,200. Given both weights equal value, a total value of 76,000 was reached with an improvement value of 65,200 and an undisputed land value of 10,800.
Thank you. Questions from?
I just wanted to just reiterate, Mr. Matthew noted that the quality condition adjustment was partially due to the renovation, and that is taken care of in the condition adjustment of the property, not in the quality. So we don't feel that a quality adjustment is accurate for this property.
One quick thing, that quality adjustment is by looking at the quality of the features of the property after they were redone. The condition is of the current condition of the property and not the build out materials and the items used to construct the property. Therefore, the quality was deemed better for the comps than the subject.
Thank you, Patrick. Questions from the commission? Hear none, do I hear a motion?
Mr. Chair, I'm just going off a common comp between the two. So I'm looking at a total value of $89,950. That's $10,800 on the land and $79,150 on the improvement.
Okay, we have a motion. Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted.
Next, we have the appeal of Eli Edwards Enterprises Incorporated versus Assessor L.G. Williams in the Orleans Parish Board of Review, docket number 23221-74047, and this is for 2112 Clare Street.
We're asking 72,600.
Go ahead, Mr. Russell.
Oh, I'm sorry, I was waiting. The subject is a multifamily property located in the Magnolia neighborhood. We originally valued the property at 112,400. The board review affirmed that value. The fee simple appraisal performed by our office was at 99,200, which is a little more accurate than the mass appraisal valuation. It's also supported by the tax commission's sales comparison approach. Their sales comparison approach was 102,000. Before an income approach was used to lower the value to 93,000. So we're asking the commission uphold the revised valuation for the property at 99,200.
We'll hear from Nicole, the LTC appraiser.
Yes, good morning. Nicole Singley, appraiser on behalf of Louisiana Tax Commission. I personally completed an exterior site visit of the subject located at 2112 Clara Street. The subject appears to be overall fair condition. It did suffer from physical deterioration, evidence of deferred maintenance. The property owner did agree to accept the assessor's land value of $16,800 and the building area of 1,106 square feet. I completed both the sales comparison approach and income approach to value. Both values were considered and given equal weight, arriving at an estimated fair market value of $93,000. So $16,800 to the land, $76,200 to the improvement for a opinion of market value of $93,000.
Thank you.
You're
Any
welcome.
questions from the commission? Hearing none, do I hear a motion?
Mr. Chair, I have a motion to accept the assessor's value of $99,200, which is $16,800 on the land, $82,400 on the building, total of $99,200.
Okay, we have a motion. Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted.
Next, we'll take up docket number 23221-74049, and this is for 2801 Josephine Street.
We're asking 109,000.
Okay, thank you. Mr. Russell?
Yes, this is a two-family property located in Magnolia neighborhood as well. We initially valued the property 228,500. The tax commission came in at 187. We're at 192 for the revised valuation. However, I wasn't able to provide documentation to the commission for this one. We had a communication error. So we're okay with the tax commission's appraised value of 187, considering it's 5,000 difference from where we're at.
Any questions for Nicole, the LTC appraiser? Hearing none, do I hear a motion? Any questions from the commission? I'm sorry. Hearing none, do I hear a motion?
Mr. Chair, I move to accept the total value of $187,000, $15,300 for land, $171,700 for improvements.
Okay, we have a motion. Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted.
Next, we have docket number 23221-74051, 2820 Johnson Street.
We're asking 61,200.
Okay, Mr. Russell?
Yes, we valued the property at $132,200, which was affirmed by the Board of Review. We provided a fee simple appraisal for this property that valued the property at $110,000, which we think is more accurate indicator of value. It's slightly higher than the commission's value, but it's within range, and we're asking for the 110.
Okay, we'll hear from the LTC appraiser. Patrick?
Patrick Matthew, Louisiana Tax Commission appraiser. This is an appraisal of 2820 South Johnston Street. I personally did an exterior inspection of the property. 3 comps are shown in my report and a market approach. Those comps range from 75,300 to 94,900, and a market value in the sales comparison approach was 85,000 was reached. Also did an income approach, which arrived at 100,500 for the subject. Given equal weight, a total value of 92,000 was reached for the subject, with 14,600 for land, 77,400 for improvement.
Okay, questions from the commission? Hearing none, do I hear a motion?
Mr. Chair, I move to take the average of both the assessor and LTC, total of 101,000, 14,600 for land, 86,400 for improvements.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted.
Next, we have docket number 23221-74062. This is for 2105 Willow Street.
We're asking 95,000.
Mr. Russell?
Yes, this property is another multifamily property located in the Magnolia neighborhood. We originally valued the property at 152,800, which was affirmed by the Board of Review. Our revised appraisal is $130,000, which we think is an accurate indicator of value. It's more specific to the property, considering that the insurance the subject property is insured for 100,000 plus the land of 34,800 would put it at 134,800, which is higher than our revised appraisal. The only issue that we have is that some of the comps in the tax commission's appraisal is not actually an arm's length transaction. The first one on Liberty Street is a bond for deed. The second one and the third one have some severe condition issues with it. Now they call it fair condition, but there are no photos and repair estimates. There's only an exterior inspection. So because of that, the insurance value supporting our value, we're asking for the $130,000 value.
We'll hear from the LTC appraiser. Nicole?
Yes, good morning again. Nicole Singley. I did personally complete, it was exterior only. I did make that word extraordinary assumption based on uncertain information and just from what can be seen from the exterior, as there was evidence of physical deterioration, deferred maintenance from the exterior, giving it an overall fair opinion of condition. Let's see, the taxpayer agreed to accept the assessor's land value at the 34,800 and the building area of 1296. Both the sales compare approach and income approach to value were developed. I did equal weight distributed to both approaches, arriving at the value of an opinion of market value of 108,000.
Thank you, Nicole.
You're
Questions
welcome.
from the commission? Hearing none, do I hear a motion?
Mr. Chair, I'd like to make a motion to, I'm gonna go with the common average of one of the common comps, and it falls right in between both appraisals. I'm gonna ask for 114,000 total value. That's for 34,800 for the land, 79,200 for the improvement.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted.
Next, we have docket number 2322174065. This is for 2833 South Johnson Street.
We're asking 60,000.
Thank you, ma'am. Mr. Russell?
This property is a multifamily property in the Central City North neighborhood. We originally valued it at 102,600. It was affirmed by the Board of Review. We did a fee simple appraisal at 99,700. We're asking for that value. If you take the land plus the insurance, it's right in that ballpark of this. I mean, not saying that that's how you should value the property, but it's saying that's also a supporter of the valuation. The reason why we're asking for the 99 and not the 75 is that, like I said, that it's also a fair condition property with no interior photos or repair estimates. There's a quality adjustment. The quality adjustment appears to be the same for all houses. If you remove the quality adjustment, the tax commission's appraisal is right in that $100,000 value that we have. And like I said, these seem to be some pretty substantial reductions, 41%, 55%, and 60% reductions for comps, lead me to think that our indicator of value of 99,700 is more accurate.
Thank you, Russell. We'll hear from the LTC appraiser, Patrick.
Patrick Matthew, Louisiana Tax Commission. Once again, this property is across the street and next door to the last previous two. Same three comps were used. Once again, I personally went to the property, walked around the property, looked at the deferred maintenance, and just like in previous testimonies, found it to be in fair condition. Same thing with the quality, items used in constructions, all that did not equate to the comps I found and the data that they showed. So once again, I arrived at 72,000 in a market approach and a 77,900 with an income approach. Therefore reached a overall value of 75,000, 14,000 for land, 61,000 for improvements. Thank you.
Thank you, Patrick. Questions from the commission? Hearing none, do I hear a motion?
Mr. Chair, I have a motion to make a total value of $90,000, $14,000 of land, $76,000 improvement, total of $90,000.
Okay, we have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted. Thank you, Patrick.
Next, we have the final appeal for Eli Edward Enterprises, and it's 2322176160, and it's for 3532 Toledano Street.
We're asking 42,800.
Okay, Mr. Russell.
We're asking the commission to affirm the Board of Review's valuation. It's a uniform land right for the entire neighborhood, and is supported by the tax commission's appraisal.
Okay. Any questions from the commission on this?
Mr. Chairman, I move that we accept the parish assessor's appraisal of 53,600. No improvements were needed for a total of 53,600.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted.
Thank you. You too.
Next, we have the appeal of Lisa P. Morello versus Assessor L.G. Williams and the Orleans Parish Board of Review, docket number 23221-72136. And taxpayer's not here.
Yes. So originally the property was valued at 259,400. It was acquired in a quick claim foreclosure. And just to throw it out there, the assessor's office did offer to settle for 250,400, which is the commission's appraisal value. I mean, it's like $8,000 difference from our valuation. It was rejected we didn't hear back from the taxpayer.
So the city of New Orleans is okay with the LTC tax appraisal of 250,400.
Yes, sir.
Okay. Questions from the commission? Hearing none, do I hear a motion? We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted. Thank you, Sandy.
Thank you.
All right. Thank you, commissioners.
We're going to take a 2-minute break, kind of reset, and then we'll be ready to go.